Good morning to everyone present at the public hearing of the Vetting Commission established under the law number 65 on the external evaluation of judges and candidates for the position of judge of the Supreme Court of Justice. I am Andrei Bivol, I'm the deputy chair of the commission and the chair of panel A, and I declare this session open. This hearing is carried out on the basis of law number 252 on the external evaluation of judges and prosecutors and on the basis of the commission regulation. And today's subject is Madam Angela Braga, judge at the Center Court of Appeal, which used to be called the Chisinau Court of Appeal. Judge Braga, welcome. On the 16th of April 2025, the Superior Council of Magistracy, by decision number 181/15, has rejected the evaluation report issued by the Commission with regards to you and has ordered the resumption of the evaluation. And thus, in compliance with Article 20 of the Law 252, the Commission has sought you to participate in today's hearing. With me here are the two other members of the panel A. To my left, Madam Lovely Perling, International Member of the Commission. To my right, Lilian Angel, National Member of the Commission. The panel is assisted also by members of the Secretariat, and behind you there are representatives of the media and of the public. In the room as well with us here today is a photographer who will be taking some pictures in the first few minutes. The hearing is carried out with Romanian English simultaneous interpretation to allow for accurate interpretation. Everyone is kindly asked to speak clearly, slowly. The hearing is audio and video recorded. The recordings are usually made available within 3 days after the hearing on the website of the Commission, of the Vetting Commission, www.vettingmd.eu. During the hearing, the members of the Commission will be asking you questions. Please answer them truthfully, clearly, and succinctly. Your explanations are important for the Commission's efforts to check, to verify your ethical and financial integrity. At the end of the hearing, you'll be able to take the floor for a short discourse. We'll be taking into account your privacy when asking questions and the privacy of members of your family and of people close to you, so we will not mention details that are not that don't necessarily require to be named, such as identification numbers, bank account numbers, addresses of real estate, and you are kindly asked to also follow that spirit to protect privacy. Now, a brief review of the evaluation of Madam Braga. The Commission initiated the evaluation of Madam Braga on the 11th of April 2024, notifying her by email and asking her to fill out and send back to the Commission an ethics questionnaire and the declarations provided for the Law 252. Madam Braga has returned the questionnaire and the filled out declarations on the 30th of April 2024. On the 13th of August 2024, the Commission informed the subject that her file was randomly distributed to Panel A, consisting of the members Andrei Bivol, Lovely Perling, and Lilian Angel. The subject confirmed receipt of that notification, did not seek the recusal of any member of the panel. On the 12th of March 2025, the panel adopted the evaluation report, recommending that Judge Braga pass the external evaluation against the criteria set out in the Law 252. On the 16th of April 2025, the Superior Council of Magistracy rejected the evaluation report and ordered for the evaluation of Madam Braga to be resumed. The SCM established that on the 17th of March 2025, the Prosecutor General has initiated a criminal case on the basis of reasonable suspicion that the crimes provided for in Article 326 were allegedly committed, paragraph 1 and 1 prime in the Criminal Code. On the 23rd of June 2025, the Commission has sought from the Office of the Prosecutor General copies of the materials that were shared by the Prosecutor General with the Superior Council of Magistracy that served as a basis for the action that were taken regarding the criminal investigation of Madam Braga. But that request was not responded to. The representatives of the Office of the Prosecutor General have informed by phone the Commission that that request would be responded to by the Chisinau Municipality Prosecutor's Office, who was carrying out the criminal investigation of the subject Angela Braga. On that day, the Commission has also sought from the Chisinau Prosecutor's Office copies of the materials regarding that particular case file, the criminal investigation, that have to do with the investigative measures taken with regards to the subject, and also has asked for relevant excerpts of that would lead to the reasonable suspicion that she had allegedly committed the crime that she was charged with. However, the request was rejected because the criminal investigation was not finished. The criminal investigation of Angela Braga was not finished at that time, which would make it impossible to present the materials that were sought. On the 23rd of June, 2025, the Commission filed a request with judicial inspection asking to be informed about whether the notification filed by the SCM member Ion Guzun as regards the subject was finalized, and to provide a copy of the decision or of the report that was put together. In its answer of the 3rd of July, the 3rd of July 2025, the Commission was informed that the disciplinary action was underway and that there was no solution yet on the case. On the 21st of July 2025, the Commission has again asked from the Municipal Prosecutor's Office a copy of the order on searches and other related orders with regards to that particular criminal case against the subject, and asked for a copy of the reports or minutes regarding the criminal investigation actions or special investigative measures not taken related to a particular phone call between the subject and Judge Tamara Mereuța dated 20th of January 2025. And, as the case may be required, annexes to that were also sought. But that request was rejected for the same reason: confidentiality of the criminal investigation procedure. On the 1st of August 2025, the Chisinau Municipality Prosecutor's Office has provided to the Commission several procedural documentation, such as order on the joining of criminal cases, warrants for searches, and the reports of the searches. And the subject has provided the Commission with order on the initiation of the criminal investigation and the order on the charges. And that actually showed general information regarding the crimes the subject allegedly committed. Now, in the same train of thought in the investigation, on the 3rd of June 2025, the Commission has asked from the SCM copies of the materials handed over by the Prosecutor General that were served as a basis for partially admitting the notification regarding the issuance of the agreement to carry out certain criminal investigation actions with regards to Madam Braga. On the 4th of July 2025, the SCM has communicated the fact that the materials transmitted or passed over to the Prosecutor General concern other people as well, and in order not to harm the criminal investigation, it was not possible to grant the Commission's request. And taking into account these circumstances, on the 9th of August 2025, the Commission has requested again from the Prosecutor General, from the SCM, the materials that were handed over by the Prosecutor General Ion Munteanu to support the notification to release that agreement to carry out certain actions of criminal investigation against Madam Angela Braga. On the 26th of August 2025, the Office of the Prosecutor General handed over the request to the Municipal Prosecutor's Office, informing the Commission about the impossibility to provide the requested material, arguing that the criminal investigation had not been finalized. By its answer on the 2nd of September 2025, the SCM reiterated that it cannot allow for the request of the Commission to gain those materials from the Prosecutor General. However, it handed over a copy of the administrative file with regards to that procedure regarding the agreement of the SCM for the conduct of certain criminal investigation actions with regards to the subject. And there has been also a report of the judicial inspection following that notification filed by the member of the SCM, Ion Guzun, with regards to the illegal actions of certain judges. And thus the Commission has filed two requests to the Office of the Prosecutor General, two requests to the Chisinau Municipality Prosecutor's Office, and two requests to the Superior Council of Magistracy in order to obtain the documentation, the primary documentation that would prove the reasonable suspicion that the subject has committed the alleged crimes. And all the requests of the Commission had been rejected. Concurrently, from the 17th of July 2025 through the 10th of September 2025, the Judge Braga was asked 3 rounds of questions, and she provided answers. On the 24th of October 2025, the Commission notified Madam Braga with regards to the identified doubts, and she was invited to participate in the hearing of today. On the 24th of October, Judge Braga confirmed receiving the notification of hearing, and she requested that the hearing be carried out in a closed session. On the 29th of October 2025, Judge Braga was informed about the fact that the Commission would partially allow for the carrying out of the hearing in closed session. On the 29th of October, Madam Braga sought access to the materials of the case, and access was granted to those materials on that same day. Now, Madam Braga, is there anything you would like to add or amend, change with regards to the answers you've provided to the Commission's request? I have already provided all of the information that I had. I have provided answers to the questions that were raised, that were asked, and I have also provided written explanations with regards to the notification that I got. And I think you've already become or made yourselves familiar with that, and nothing for me to add. Thank you. The answers that you provided during the initial evaluation in the ethics questionnaire and in the declarations sent on the 30th of April 2025, are they accurate to this day? Yes. Now, taking into account that we've decided to grant the closed session request, before we start asking the questions, the session will be closed, and all the members of the public, of the Secretariat of the Commission, are therefore asked to leave the room, except for the technical staff, who is taking care of the recording.
Mrs. Braga, would you like to make any short statement before we conclude this hearing? Yes, if possible. I would take advantage of this possibility. Dear members of the panel of the Vetting Committee, the Superior Council of Magistracy invoked that the Vetting Commission should check on the circumstances about starting the criminal investigation on alleged corruption acts, which allegedly were committed during the period subject to examination, to evaluation. I could say that based on the documents presented by the criminal investigative bodies, as you mentioned, these are some events which allegedly happened during April 25, March 10, 2025. And in the report of March 12, the Commission mentioned that the period for verification of ethical integrity of Braga judge could include the past 5 years or 10 years, calculated regressively from the first day earlier than the notification date. This is in point 21 of the report from March 12. The same situation with the calculation of the term, was applied to all the subjects of evaluation. And I saw that in the reports of the Commission. Taking the date of my notification about the evaluation, 11th of April 2024, as well as the legal provisions of 252, Article 11 about period of evaluation, it results that the Commission has no right to say an opinion about the circumstances for ethical integrity which exceeds the verification period, which means the period after the 10th of April 2024. That's why the solution of the Commission adopted by the report of April 12, I consider this should be unchanged. It is important, in my opinion, to reiterate that we shouldn't confuse the evaluation period with the period in which the evaluation took place, or these are two different periods of time. The evaluation period is calculated regressively from the first day of the notification, and the period in which the evaluation takes place is the period after the notification, before the adoption of the solution regarding the evaluation. The Commission's opinion about the acts taking place outside the verification period, in my opinion, is a violation of provisions of Law 252 and my rights as a subject of evaluation. Or exceeding the evaluation period will lead to violating the principle of security of legal relationship, provisions of Article 6 of the European Convention. I could also mention cases of the European Court for Human Rights, Volkov versus Ukraine case, by which CEDAW provide violation of the articles of the Convention by non-observance of the principle of non-observance of legal relationship. I think the judge was sanctioned, was released from office for disciplinary violations which were committed 10 years before. Although the Ukrainian legislation didn't provide for the period in which those violations could be done, the court considered that this is a quite long period of time, and although it wasn't established anyway, the security of legal relationships was violated. In our case, this term is strictly provided by the law, and it shouldn't be violated. I'd like to say that the invocations of the Superior Council of Magistracy will lead to rejecting the report and the reevaluation are just suspicions, and this doesn't equivalent to the existence of these facts because there is no irrevocable decision in disciplinary proceeding or criminal proceeding. Recently, as I mentioned in the CSM meeting, I saw that against one of the judges who was concerned in the same suspicion, the case was seized because of lack of reasons. During the reevaluation procedure, it results that neither the criminal investigation body nor the Council of Magistracy haven't provided documents from which it would have be any suspicion of the fact that the subject committed those acts. So the presumption of innocence wasn't overturned and prevails over all the suspicions against me. And the Evaluation Commission doesn't have any reason to decide me that I wouldn't pass the evaluation. Regarding the report of the judicial inspection presented to the Commission, I would like to say that this is not an final administrative document. Given the legal provisions after the issuance of the report, the disciplinary case should be examined by the disciplinary board, and the decision of the disciplinary board could be appealed with the Superior Council of Magistracy, and the decision of the council could be appealed at the Supreme Court of Justice. Only then we can speak about establishing or non-establishing a disciplinary violation. So I support the arguments mentioned today, and also in the written documents, in the responses at the rounds of questions. And I say that I wasn't involved in corruption acts. I exercised my duties accordingly. Since there are no sure information proving my guiltiness through irrevocable judicial acts about the acts imputed to me, we are in circumstances in which my discussions with my colleague or the report of the judicial inspector in pending procedure can't influence the vetting commission to adopt another solution than the one that I have passed the evaluation. The Superior Council of Magistracy, through its decision, ordered the reevaluation referring only to the circumstances relating to the initiation of the criminal case. There were no uncertainties referring to the verification of the ethical integrity and financial integrity exposed in the report from March 12 on the dates established in the conclusions of the Commission indicated in that report. In these circumstances, no reference was made in neither in the reevaluation during the re-evaluation process. I was a little bit unhappy about the fact that the circumstances researched by the Commission during 9 months for the period subject to evaluation weren't appreciated by the Superior Council of Magistracy at all. But as I mentioned, these circumstances haven't changed. They stayed the same. So, taking into account that the things invoked by the CSM decision on 7th of April refer to a different period than the one subject to evaluation, on which they have the Commission has the right to verify, the same solution only can be adopted, the one that was adopted through the report of March 12. I kindly ask the Commission to apply equal treatment in my relationship compared to other colleagues which were subject to evaluation and for which the period was 5 or 10 years, calculated regressively from the first day earlier than the notification date. I am aware of the fact that the information about the criminal case made public through leaks of information from some authorities shocked the public opinion. I think this was one of the reasons why it determined the members of the Commission to vote for the re-evaluation. I wasn't present, as the members of the Commission weren't present when the report was examined by CSM. I didn't have the possibility to present evidence, to make explanations. Maybe if I were present, I would have presented evidence, and maybe that solution that they adopted by a decision of the 17th of April wouldn't have adopted. And I think when the career is at stake, when the reputation of a person and health of a person is at stake, we shouldn't rely just on the circumstances set. We shouldn't rely on circumstances that have been interpreted by somebody. I hope that the vetting committee will be objective as it was during the evaluation process, and it will rely on the legal provisions governing this case and will evaluate all the records and will adopt finally a report which is equal to the previous one. Reasons that would change the solution adopted in my regard, I think no such things were presented. Thank you, Mrs. Braga. Now we are at the end of this hearing, and I kindly ask Mrs. Braga for the information provided and the answers provided during the re-evaluation and in the public hearing today. Following the hearing, our panel will draft a report where it will mention the conclusion about whether the subject meets the ethical and financial integrity criteria stipulated in Law 252. The panel will try to finalize and approve its re-evaluation report and announce the conclusion as soon as possible. This hearing is announced closed. Thank you.